Silence, compromise. Render in judgment in the matter of Fearn and others, and the Board of the Trustees of the Tate Gallery.
The following is a brief media statement. It does not form part of the reasons for the decision of the full judgment of the court, and the written judgment of the court is the only authoritative document. The appellants are the owners of 4 flats adjacent to the Tate Modern Art Gallery on the south bank of the River Thames in central London. The flats are of a striking modern design and include winter gardens, a type of indoor balcony with floor-to-ceiling windows looking out over London. These flats were designed and constructed between 2006 and 2012. Around the same time, a new extension to the Tate Modern was built, called the Blavatnik Building. On the top floor of the Blavatnik Building, there is a viewing gallery which runs all along the 4 sides and allows visitors to the Tate Modern to enjoy a 360-degree panoramic view of central London. The viewing gallery attracts hundreds of thousands of people each year, with a maximum of 300 visitors at one time. From the south side of the viewing gallery, visitors can see directly into the winter gardens, through to the general living accommodation of the flats. Visitors to the viewing gallery frequently look into the appellants' flats, sometimes with binoculars, and less frequently take photographs, which they post on social media. The appellants claim that by allowing visitors to overlook into their flats, the Tate had committed the tort of nuisance and sought an injunction against the Tate to close the part of the viewing gallery which gives views into their flats. Private nuisance is a common law tort or civil wrong, which is defined as an unlawful interference with a landowner's use or enjoyment of their property. The trial took place before Mr. Justice Mann in the High Court of Justice on the 2nd, 5th, 6th, 7th and 12th of November 2019. He dismissed the claim and the flat owners appealed to the Court of Appeal. The Court of Appeal unanimously dismisses the appeal. The court has dismissed the appeal on the basis that overlooking does not fall within the tort of nuisance. Over the hundreds of years that the tort of nuisance has existed, there has never been a reported case in this country in which a court has found that overlooking by a neighbour constituted nuisance. On the contrary, courts have recognised that subject to planning permission being given, an owner of land may create windows which overlook a neighbour's property. The Court of Appeal has held that there are other laws which protect privacy, including the law relating to confidentiality, misuse of private information, data protection, the Data Protection Act 2018, harassment and stalking, the Protection of Harassment Act 1997. Parliament has created legislation in this area and is better able to weigh up the competing interests of landowners than the courts. It is for those reasons that the Court of Appeal makes the following order. 1, that the appeal is dismissed. 2, that the undertaking given by the respondent in the order of Mr. Justice Mann, dated the 12th of February 2019, relating to the opening hours of the viewing gallery, is discharged. 3, there shall be no orders to costs, and that is for the reason that we decided this appeal in the same way as the judge, but for different reasons. 4, the appellant's application for permission to appeal to the Supreme Court is refused. I repeat that the statement which I read out earlier does not form part of the judgment itself. The only authoritative document in this case, for our reasons and for the decision, is the written judgment, and that judgment, which is a public document, is available at www.judiciary.uk/judgments.